We are going to share some information today about fair housing. So, this is our agenda. So, we're first going to talk about the Housing Rights Center, which is the organization that I'm a part of. We're going to talk about some of our free services. And then we're really going to focus on what is fair housing. So, we're going to review federal and state fair housing laws that give tenants certain protected classes or characteristics in housing. So we're really going to talk about how do we spot and report discrimination if it does occur, and if we're a landlord or housing provider on the call, it's really helpful information to know about what laws apply to your property. So we're really going to focus on source of income discrimination, as well as the right to request changes in our home if we have a disability, which are called reasonable accommodations and modifications. And then we have a short section on practicing fair housing, where we're going to talk about allowable tenant screening criteria and some prohibited practices. Lastly, I'm going to provide some resources and some information on resources, let's say for an eviction or how to contact us. So I want to start by introducing the Housing Rights Center. So this is the organization that I'm a part of. And we were founded in 1968, which is actually the same year that Congress passed the Fair Housing Act. So that's really when it became illegal in the US for a landlord or a housing provider to discriminate against a tenant based on their protected characteristic. We're the nation's largest nonprofit civil rights organization dedicated to fair housing, and we serve LA County and Ventura County, and our services are free and available in many different languages. So one of our main services that's really important for any tenants and any landlords that we have on the call is that we offer free housing counseling. So this is a free service, it's private and it's confidential, where you can get in contact with our housing counselors and get the answers that you need. So our housing counselors, they're not attorneys, and that means that they can't provide direct legal advice, but what they can do is provide legal information, resources, and referrals. So here are some types of questions that housing counselors can help with. Very common questions are, I want to get my security deposit back. How do I do this? Or what can I do if my landlord's not making needed repairs in my unit? What are my next steps? Or is it illegal to be treated differently in housing because I have children? So hopefully we're going to answer that today. Or I have a disability and I'm requesting a change in my housing, but my landlord's ignoring me. What are my options? So these are just some of the questions that you can reach out to our housing counselors and receive assistance on. So to get in contact with our housing counselors, we have a few different options. Your first option is you can give us a call at 1-800-477-5977. And this information, it's found on our website, so it's always there if you need it. But you can give us a call on our hotline. And if no counselors are available when you do call, please leave a voicemail with your name, your callback number, and some good times when they can call you back, and expect that they'll call you back within that week. If you would prefer, you can also send an email, or instead you can send an email to info@housingrightcenter.org. So it's the same service either way if you choose to call or email. You can also come in person. We have an office in Koreatown, and our address is right here and also on our website. So our main office in LA, it's open Monday through Friday from 8:30 to 5 o'clock. So I would say if you're going in for housing counseling, you're hoping to speak with someone that day, I would recommend getting in there before 4:30, just so you can make sure that you have enough time to speak with them. So we also offer discrimination investigation and enforcement. So what sometimes happens is that someone reaches out to our housing counseling department and they're screened and they may be experiencing discrimination. So we do have these departments that can help a tenant essentially build a case and investigate if that discrimination really is occurring. So they can often help mediate between a landlord and a tenant, help file a complaint with the California Civil Rights Department, or even litigate. So we also, last thing I'll plug in for this is that we also have our outreach and education department where we offer free community workshops across LA County and Ventura County. And we do offer something called Project Place. So, Project Place is a free newsletter of affordable rental listings that we essentially put out every month. So, you can sign up for email updates to receive this every month in your inbox. And essentially, it's a really good resource for anyone who's looking for new affordable housing. So, they're looking for housing opportunities where they can apply. So we're not in charge of any of these listings. We don't have the power to have someone's application accepted or anything like that. But we are trying to compile the open listings that we do see into a resource that someone can subscribe and sign up for and receive every month. We also have a new resource called Project Place Toolkit. So this is a much smaller resource. It's about 12 pages long. It's free to download from our website, available in English and Spanish. And essentially, this really contains a lot of information on housing search resources, knowing your rights, and the basics of renting. All right, so let's now pivot and start talking about fair housing. So this is normally the first question I get asked. We're at a fair housing workshop. What is fair housing? So the definition that I like to give for fair housing is really the ability for people of similar income levels, so they're making similar amounts of money, to have available to them the same housing choices regardless of personal characteristics or protected classes that we're going to review today, like our race, our national origin, disability, and any other characteristic protected through law. So, why that definition is important is because a fair housing violation, something that we encourage tenants to report to our organization, is anything that's limiting their housing choice. It's limiting their ability to live where they want to live and can afford to live based on a protected characteristic. All right, so the second question I normally get asked is, when do these fair housing laws apply? So a lot of people think that they only have the protections that we're going to talk about today when they're an in-place tenant, when they're actually renting a unit. The truth is, we do have protections when we're renting a unit, but we also have these protections when we're buying a home, taking out a loan, or lending from a bank, or even if we're just a prospective applicant. And that's really important. Even if someone's just looking around, talking with a leasing manager, or putting an application in at a property, they can still experience discrimination at that stage that they should report. It also doesn't really matter what type of home or residential dwelling someone's living in, they also have these protections. So people have protections in apartments, condos, houses, duplexes, residential motels, transitional shelters, mobile home parks, and even vacant lots if they were being sold for housing. It's also important to talk about who can be held liable in these fair housing cases? Who can be held as a responsible party? Who's responsible for making sure that people's fair housing rights are respected? Well, we like to say that the liability flows upward to the owner. So it's not only the property owner who's responsible for their own actions, but they're also responsible for everyone who's employed to work on that housing, right? So the property management company, or maybe there's an on-site manager or maintenance and administrative staff. All of these groups can be held as a responsible party, but it's ultimately the property owner who's responsible for everyone. All right, so what we have on the screen here are the federally protected characteristics. So this is through a US law called the Fair Housing Act, and this is a federal law that grants tenants the protections that we have on the screen here. So these are protected classes or characteristics, which mean that we should not experience discrimination in housing based on these classes. So the first one is race. We also have protections based on our color, which really means our skin tone, protections based on our religion, our national origin or ethnicity, our sex, which includes bans on sexual harassment, familial status, which we're going to talk about more, and if we have a disability. So once again, these are the federally protected characteristics, meaning anywhere a tenant moves in the US, they would have these protections. So familial status, what does it mean as a protected characteristic? So it essentially protects any household with a minor, someone under the age of 18, living in that household. It also covers households that are expecting the arrival of a minor. So maybe someone's pregnant or they're going through the process of adoption, a grandparent's getting custody. In all of those situations, they could experience familial status discrimination. So, what are some ways that familial status discrimination shows up? Well, it could show up by a landlord or a housing provider locating families in a certain part of the property. So maybe they only rent out the bottom corner units to families with small children. So maybe they cite a safety concern or a noise concern. But the truth is, if a landlord is only renting certain parts of the property to people based on a protected class, that can be discriminatory. It can also show up as unreasonable occupancy restrictions. So, restrictions that say how people are related or how many children can be in that unit rather than occupants, as well as overly restrictive rules at that property in the lease agreement that limit access to services and facilities that are offered to tenants with minor children. Lastly, any ads that we see that say no children or adults preferred, that would be an example of familial status discrimination that we would really encourage you to report. All right, so moving on now, national origin discrimination. So what does national origin discrimination mean? Well, it can mean our country of birth, like maybe we were born in a different country, but it can also mean ethnicity, which isn't always tied to one specific country. It covers our physical and our cultural traits, like our clothing and our hairstyles. It also covers our immigration and citizenship status. Lastly, it covers our primary language, or maybe if we speak English with an accent. All of that is protected against discrimination through federal law. So, what are some ways that these national origin cases are formed? What are some examples of this form of discrimination? Well, it could look like a landlord denying a rental application based on that tenant's language or their accent. So even if that landlord doesn't speak Spanish or Tagalog or whatever language that applicant speaks as their primary language, they cannot use that as a basis for their tenant screening, right? So they can't reject tenants for not speaking their same language. It can also show up as a landlord charging a higher security deposit or higher fees because that tenant is undocumented. Lastly, it can show up as the housing provider, the landlord, or anyone who's working at that property, or even neighbors harassing tenants with ethnic slurs. So if someone was experiencing that, I would really encourage them to document the issue and then contact our housing counselors for next steps and more information. All right, so moving on now, sexual harassment. So it's important to mention that federal protections banning sex discrimination also ban sexual harassment in housing. So sexual harassment, it can take a lot of different forms of behavior. It can be physical, it can be verbal, or it can be visual. So there are basically two forms of sexual harassment in housing. And the first one's called quid pro quo, which essentially translates to this for that, right? So there's an exchange happening there. The housing provider, the landlord, is offering something like reducing rent or doing needed repairs or even stopping an eviction to a resident or an applicant in exchange for sex. It's important for us to remember that that would be illegal even if the offer was accepted because of the difference in bargaining power between a housing provider or landlord and a tenant. There's another form of sexual harassment called creating a hostile environment. That's when conduct of a sexual nature, it's unwelcome, it's severe enough that it interferes with a resident's right to enjoy their housing. So that could look like persistent comments about someone's body, attire, or sex life, inappropriate questions, or even persistent requests for dates. All right, so moving on now. We've gone through the federally protected characteristics under the Fair Housing Act. And now what we have on the screen here are the protected characteristics in California. So in California, we have everything that we've covered so far in addition to what we have on the screen here. So this is through a California law called the California Fair Employment and Housing Act. And it grants tenants the additional protected classes of ancestry, sexual orientation, gender identity, and gender expression, marital status, which would be if someone experienced discrimination on the basis of the fact that they're single, married, or widowed. We also have protections based on our military and veteran status, medical condition, which normally includes information maybe a housing provider may have about a family's medical history. And lastly, source of income. So source of income is a big one that I want to talk about today because the law is still relatively new. So source of income was actually added as a protected characteristic relatively recently. So it went into effect in 2020. And so what that means is that a lot of tenants, a lot of landlords, we're all learning about what source of income discrimination can look like. All right, so when we say that source of income is a protected class, just like our race is a protected class, or if we have a disability is a protected class, what we really mean is that all lawful sources of income, and what I mean there is that all legal forms of income that a tenant's using to pay their rent at that property cannot be used by the landlord as the basis for differential treatment. Another way to say that is that a landlord can't use the fact that someone is using public benefits or any other form of income that is legal to have as the reason for different treatment, to treat them differently. So when we're talking about legal forms of income, protected forms of income in rental housing, we're talking about all public benefits, including Section 8 or housing choice vouchers, SSI, SDI, GR, rental assistance, rapid rehousing, homeless prevention, and security deposit assistance. We're also talking about non-traditional forms of income, like non-work income, like child support or alimony payments, or even financial aid. So what are some ways that source of income discrimination shows up in rental housing? Well, we used to see a lot of advertising statements that used to say no Section 8. So in California, it's no longer legal for landlords to advertise or have that preference in renting to tenants who are not using Section 8. It can also look like a landlord refusing to accept or approve applications from tenants who are using Section 8 or housing choice vouchers. It also, and we're seeing more situations like this show up, where a current tenant, a current resident at that property finally gets a new form of income that's going to make paying their monthly rent a lot more manageable. So they finally get a new form of income. Maybe it's a public benefit or public assistance, and the landlord refuses to fill out the paperwork that would allow that tenant to use their new income at that property. That also counts as a source of income discrimination. Why? Because it's limiting the housing choice of those renters based on a protected class. In California, as we talk about, right, source of income is a protected class. So it can look like that. And if someone was experiencing that, I would really encourage them to make sure that you keep all of that documentation and then contact our housing counselors for some next steps. I also want to highlight in California, we had a new law go into effect called SB 267. And so, what this law essentially says is that for someone who's using a government rent subsidy, so they're receiving assistance from the government to help pay their rent. So, something like Section 8, they're receiving and they're using that at their rental property. So for those applicants and those applicants only, they need to be given the option of providing alternative evidence instead of that credit check. So some applicants who are using a government rent subsidy, they may be fine going through that credit check, and that's totally okay. But they need to be given the option of providing alternative, verifiable evidence instead of that credit check if they are using a government rent subsidy. And that's under that law, SB 267, if anyone wants to look into that more. It can also show up as a landlord applying different terms or criteria. So they're essentially putting up barriers for renting that unit to tenants who are using something like Section 8. So maybe they're charging a higher rent, or they're having a tougher application screening process, or insisting on special documentation that's not required of other tenants, really to make it so those applicants can't rent at that property. It can also show up as a landlord applying income standards incorrectly. So the income standard, that's the part of the application that says tenants have to make 2 times the rent, or they have to make 3 times the rent to live here. So that income standard, it is legal for landlords to have, right? So they're totally allowed to have that income standard, but it must be applied to the tenant's portion of the rent only. And so we're going to talk about what that looks like with an exercise. So in this example scenario, an apartment's renting for $1,000 a month. The application criteria requires an income of 3 times the rent. So that's the income standard, 3 times the rent. The applicant has to make 3 times the rent in order to live there. So an applicant applies who's making $300 per month at their part-time job, and they have a housing choice voucher or Section 8 that's paying $900 a month. And so I want us to think about, does this applicant meet the income requirement? Would they be making 3 times the rent? And just think that to yourself, would it be yes or no? And there's a few different ways that you can read this, right? So one of the first ways that you could read this would be the rent is $1,000. The income standard is 3 times the rent. So this applicant would need $3,000, right, to be able to rent here. Well, the way it actually should be applied is that this applicant does meet that income standard. Why is that so? Well, once again, that income standard, it can only be applied to the amount of rent or the portion of the rent that the tenant is personally responsible for paying. So because in this example, the total rent is $1,000, and this applicant has a housing choice voucher that's paying $900 a month, this applicant's personally responsible for paying $100 each month. So that's what they personally have to pay. This applicant making $300 per month at their part-time job, they're technically making 3 times what they personally have to pay, and therefore their income qualifies them. So why we go through this is because if a landlord is rejecting applicants for this reason, because they're not applying that income standard correctly, that does count as source of income discrimination. So we want to be on the lookout for that. And if we're a landlord, we want to be aware of this in our screening process. So I want to mention a few other California laws that grant tenants additional protections in rental housing. So the first one is Civil Code 1946.7. So tenants who have experienced domestic violence or other violent crimes through this civil code, they can change their locks with little notice, and that's really for safety, and they can break their lease with lower penalties if they need to move elsewhere. We also have a California law called the Immigrant Tenant Protection Act, also known as AB 291. I'll talk about this a little bit more in the next slide. We also have a law called the Unruh Civil Rights Act, and that grants tenants protections against experiencing discrimination based on their age. But age here really means over 40 years old. So anyone over 40 years old has protections against experiencing discrimination based on their age under the Unruh Civil Rights Act, that California law. Tenants also have protections against experiencing discrimination based on arbitrary reasons. So normally heard as arbitrary physical characteristics. So maybe an applicant has a lot of tattoos or visible piercings or unconventional, outfits or hair, right? Some kind of arbitrary physical characteristic, something that doesn't really tell the landlord we're going to have a good business relationship and therefore shouldn't be considered. Tenants also have protections against hate crimes or threats of violence through the Ralph Civil Rights Act, as well as this last one on primary language is really important. So Civil Code 1632 says that if an applicant speaks one of these 5 languages on the screen here as their primary language, Spanish, Chinese, Tagalog, Vietnamese, or Korean, they can bring an interpreter with them to help them understand their lease, or they can request a translated lease at no cost to the tenant. So that means that the landlord would have to pay for the cost of getting that lease translated. So I want to talk a little bit more about the Immigrant Tenant Protection Act. As I mentioned before, if we want to look this law up, it is also known as AB 291. So essentially, this California law, so it's California specific, prohibits landlords from reporting or threatening to report tenants to the immigration authorities. Landlords are not allowed to disclose information that they may have related to a tenant's immigration status. It also prohibits attorneys who are working on these housing cases for that landlord from the same types of activities, right? So they can't report or even threaten to report the immigration status of those individuals in those housing cases. If this does happen to a tenant, the law does provide them with recourse or options they can take. So they have a legal defense against an eviction from that landlord, and they also have the right to sue their landlord, called a private right of action. If someone was experiencing this, I would say feel free to contact our housing counselors. They can provide you more information and learn a little bit more about what's happening and provide you some next steps. So I want to talk a little bit more about disability. So Disability actually remains one of the top reported cases across the nation every year. So, out of all of the fair housing cases that are filed all across the nation, all across the US every year, disability actually remains the majority of them. All right, so it's still very common, and it is something that if we have any housing providers on the call, any landlords, we would really want to be aware of, and you can always contact our housing counselors to learn more about your responsibilities. So disability, beyond the word's commonly understood meaning, it also has a legal definition. So that definition is a physical or mental impairment which limits any major life activity. So, why that definition is important is because disability is really defined by the impact that it has on someone's major life activities. It's not about the actual diagnosis or disability that someone has. They don't actually have to provide that in private housing to their landlord in order to request a change, which we'll talk about. But what they do often have to provide is a verification letter that talks about the major life activity that's impacted by a disability and how that relates to what the tenant's requesting. So, major life activities that can be impacted by a disability include seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, and speaking. So tenants or applicants with disabilities, they can request changes in their home. So these changes are called reasonable accommodations and reasonable modifications. So accommodations are changes to rules, changes to policies, changes to services at the housing that make it more accessible for that tenant. Modifications, on the other hand, are physical changes to the unit or the building. So the tenant's actually modifying their unit to make it more accessible. This right to request one of or both of these two things, accommodations or modifications, is to ensure that tenants with disabilities can get equal use and enjoyment out of their housing. So that's really the goal. So accommodations, once again, a change to a service, a change to a rule, or a change to a policy. For accommodations, the landlord bears the cost if there is one. All right. And that's just the general rule. So the landlord bears the cost if there is one. I'll give you an example of what this can look like. So some common accommodations that tenants may request, right? And there are so many more than this list, but maybe changing a rental due date. So maybe someone's receiving disability assistance, but it comes in the middle of the month and rent's due or it's considered late by the third. All right, so in that example, that tenant could put in a reasonable accommodation request to change their rental due date to whatever's reasonable. And if they pay, once that accommodation is granted by their landlord, if they pay by their new rental due date, they shouldn't take on late fees, late charges, or anything like that for having their new rental due date, having their accommodation granted. Similarly, service animals and emotional support animals are accommodations. So, what that means is that after a tenant provides what they need to provide to the landlord when making the request, which would be a verification letter, the landlord, once they grant that request for an accommodation, which would be in this example, a service animal, the tenant should not pay pet rent, pet fees, pet deposits to have their accommodation in their housing. So, this whole process of requesting accommodations and how to deal with unique scenarios that may come up, this is something that our housing counselors are really available and equipped to help tenants and landlords understand. So, if you need to if you need assistance with any part of this process, this is something our organization is really equipped to help you with. So when it comes to modifications, which once again are physical change to a unit or a building, you're physically modifying that unit or that building to make it more accessible. In private housing, the tenant actually is responsible for the cost of that modification and may have to reverse that change when they move out. There is an exception, though, in federally funded housing and housing that's receiving money from the government. They actually have to operate in a way that all their services are available equally to tenants with disabilities, so they have to pay for all of those modifications. But in private housing, the tenant's actually responsible for, let's say, the cost of that grab bar in the bathroom and the installation. There are some unique situations that can come up. So once again, I just really want to encourage if anyone's in a scenario where you're trying to either understand your rights or understand this process of how do I make this request or what kind of documentation do I have to provide, that's something that I would really encourage you to contact us for next steps. All right, so moving on now. I just want to quickly talk about advertising statements and how they intersect with fair housing. So on the left-hand side here, this left four over here, we have advertising statements that would be discriminatory, right? So if we do see these, we do want to send an email or document it and let our housing counselors know. But that could look like an advertising statement that says no Section 8 or perfect for young professionals or units are not accessible or adults only. On the right-hand side, we have advertisements that are okay, right? So normally advertisements that describe the property. So no pets, no smoking, 2 parking spaces, or describe the amenities at that property. So I want to just quickly review some allowable tenant screening criteria, specifically because sometimes we get a lot of questions about how fair housing intersects with tenant screening. So can landlords ask about income? Yes, and we did talk about how there can be that income requirement, like 3 times the rent. But once again, that income standard, it can only be applied to the tenant's portion of the rent, or it can be source of income discrimination if it's applied incorrectly. Credit, so can they ask about credit? Yes, right? And landlords can check prospective tenants' credit using a social security number. But if tenants don't have a social security number, landlords must accept other documentation of their financial history. And that's really through that California law, the Immigrant Tenant Protection Act, AB 291. We also talked about SB 267, which allows tenants who are using a government rent subsidy to provide alternative verifiable evidence instead of that credit check. So something like bank statements, proof of benefit statements, and pay stubs. Can landlords ask about where a tenant has lived before? Yes, right? And they can check previous landlord references. And that's really answering the question, has the tenant paid their bills on time, or will they risk property damage by doing business with this tenant? Smoking status, so can they ask me about that? Yes, so landlords can have a no smoking policy and reject tenants for this reason. What about pets? Can they ask about pets? Yes, so landlords can have a no pet policy, but even if a property has a no pet policy, they have to make exceptions for disability accommodations or reasonable accommodations that someone may have for their service or emotional support animal. So if a tenant, which we talked about, has their service or emotional support animal granted as their accommodation in that housing, they would not need to pay pet fees, pet deposits, or pet rent. Can they ask about it's my family or my kids? So no, generally no, right? So landlords can restrict the number of occupants, but not how they're related or whether they're related. And the question that we have here is what protected class would this discriminate against? And you can ask that to yourself if you were with us earlier on the call. And that protected class would be familial status, which once again is a federally protected characteristic that protects tenants from discrimination based on the fact that they have a minor or a child with them in their housing. So this is just a little bit of a review of what we've talked about so far. This would all be considered unlawful discrimination, prohibited practices, if they're based on someone's protective characteristic. So that could look like a landlord refusing to sell or to rent housing to someone based on their protected class, like maybe their race or if they have a disability, their source of income, anything that we've talked about so far. It could also be a landlord saying that there's no housing available when there really is housing available. It could also look like having different terms or rules for tenants based on their protected class, discriminatory statements or advertising statements, a really common one being no Section 8 or adults preferred. It can also look like steering, which is when a housing provider or landlord encourages a tenant to seek housing elsewhere based on their protected class. So they say something like, wouldn't you rather be more comfortable looking in this other neighborhood or in this other building to tenants only who belong to a protected class? It can also look like threats, intimidation, harassment, or retaliation for exercising their rights, right? If a tenant was. And I want to highlight there, let's say a tenant files a discrimination claim, right? So they file a discrimination claim and an agency or an organization looks into that claim, like let's say the California Civil Rights Department, and they investigate it and they find ultimately there's not enough facts in this case that allow us to really say that this discrimination was happening. So they say ultimately this was an unfounded discrimination case. Even in that scenario, tenants should not experience retaliation or harassment for filing that discrimination claim, even if it wasn't found to be substantiated. It can also look like a housing provider denying a reasonable accommodation or modification if they're not considering the correct criteria. So if they're using faulty criteria and they're rejecting tenants' requests, tenants who have disabilities and they're rejecting those requests for changes in the home, that would count as discrimination as well, disability discrimination. This last one is kind of a catch-all. It's any action or inaction that makes housing unavailable for people based on their protected class. All right, so I want to cover a few resources now. So we're nearing the end and I want to have time just to be able to answer some questions, but I do want to provide some resources. So we've talked a lot about fair housing discrimination, what that looks like, how we can contact the Housing Rights Center to report that. But I want to highlight that tenants can still experience illegal harassment in housing that's not always based on a protected class, but it's still illegal, harmful actions that should be reported. So, what is illegal harassment? Well, legal harassment are intentional, harmful actions by the landlord or their agents with no other lawful purpose than to target specific tenants. So, what could that look like? That could look like eliminating services that were included in a lease, refusing to do repairs, entering a tenant's home excessively or taking unnecessary photographs while there, refusing to acknowledge or accept rent, asking about immigration status or any other private information, retaliating or interfering in tenant organizing. So, what can a tenant do if they are experiencing this? So, I would definitely recommend if you're in the city of LA, of course, contact LAHD, the Los Angeles Housing Department, and report that. So, we do have that local law called the Los Angeles Tenant Anti Harassment Act in the city of LA. So, you would definitely want to report that. You can also contact our housing counselors if, let's say, you're in a different city or you're in LA and you just want to learn next steps or learn some more resources. So, landlords face possible fines, criminal penalties. Tenants have an affirmative defense in an eviction case from that landlord. And tenants also have an avenue where they can sue for damages called a private right of action. So, if someone is going through an eviction, I always like to include this here. If you're in LA County and you're going through an eviction, let's say you've received a summons from the court and you're looking for eviction support. So, number one, first thing I would tell you to do is to go online to stayhousedla.org. All right, so you're going to want to search for Stay Housed LA, and you can also call their number at 1-888-694-0040. So Stay Housed LA is a coalition of different organizations and agencies that are providing free legal aid and community support. So it's not guaranteed that every applicant who applies for eviction support on their case will be matched with an attorney. But it's still important to apply, start your claim for free legal help if you are going through that eviction and you need that support. And I also want to highlight that on Stay Housed LA's website, at the top of their website, they're also doing a ton of free community workshops and clinics, virtual, in person, that I would really recommend if someone is going through an eviction or maybe they received an eviction notice and they just want to learn more about the process. I would attend one of those free community workshops if you can. There's also a resource called the Tenant Power Toolkit, and this would be a resource if someone is trying to complete an answer document to respond to their eviction case. So an answer document, it's a very specific form that you would have to fill out to respond to your unlawful detainer case. So this is a free online guide that helps tenants complete their answer document if they're running against the time frame and they need to file that answer. LA County also has self-help centers with eviction resources, and right here is a link with a step-by-step guide on the eviction process for tenants and how to prepare documents. All right, so here, once again, is our contact information, the Housing Rights Center. So once again, you can call our Housing Rights Hotline at 1-800-477-5977. You could also call, if you're hard of hearing, you can call our 1-213-201-0867 line. You can also, if you prefer, instead of calling, you can send us an email at info@housingrightscenter.org. So if you send us an email, that inbox is monitored by our housing counselors. And so you can put your question in that email, but make sure that you also include your address or any other information that they may need to start that intake with you. Once again, this is just our information. Here's our LA office in case anyone needs that. And here's also a QR code to our website where all of this information lives.